Okay, so let's unpack this. We're diving into a realm that, well, most citizens never even consider.
Right.
What happens when a citizen, representing himself, a pro se litigant, files this massive federal complaint?
And not just any complaint.
No, not at all.
Oh,
He's accusing high-ranking local government officials. I mean, we're talking multiple judges, the district attorney, state police, lawyers,
a whole system, basically.
of conspiring in a coordinated, widespread racketeering enterprise. This isn't just, a legal challenge. It's an assertion that the system itself has been weaponized.
It's an extraordinary legal scenario. And the documents we've examined, they reflect not just the claims, but the sheer meticulousness that's required to even attempt this kind of challenge.
So for our deep dive today, we are focused entirely on the details inside one monumental filing.
That's it. The Second Amended Complaint. This was filed in the U.S. District Court for the Western District of Pennsylvania back in August 2025. The case is Jackson v. Ziccarelli, et al.
And our mission for you, the listener, is to really provide a comprehensive roadmap. We want to help you understand the incredibly complex, overlapping legal claims here.
Because it's a real legal intersection. It cuts across, sensitive areas of state, family law, custody, child support.
And then it smashes right into major federal statutes. Civil rights law, 42 U.S.C., Section 1983, and of course the heavy hitter.
RI2, the Racketeer Influenced and Corrupt Organizations Act.
Yeah, so we're going to be distilling the narrative, the alleged chronology, and the specific legal counts filed against this remarkably large and, frankly, high-profile group of defendants.
Our source material for this is twofold. First, you have the 50-plus page detailed complaint itself. It's supported by extensive exhibits, A through K, which provide the factual backbone.
And paper trail.
The paper trail. And second, we have the updated federal docket, which is current through January 2026. And that gives us a glimpse into the judicial response so far.
And what truly sets the stage here, what creates that initial shock factor, is just the sheer rank and number of people named.
It's staggering.
The plaintiff, Jeremy Kevin Jackson, has named 2 judges of the Court of Common Pleas, Mikkel G. Benoni and Matthew R. Schmitzy.
2 sitting judges.
The district attorney, Nicole Ziccarelli. A Pennsylvania state trooper, Antonio S. Maffa. Then multiple private attorneys who are involved in the original custody case.
And it doesn't stop there. He also names 2 entire government agencies, the Westmoreland County Children's Bureau and the Domestic Relations Section.
This is an allegation that, it strikes directly at the foundation of local judicial and governmental integrity.
Well, that breadth is crucial, right? Because to successfully argue something like RICO, you have to connect all these seemingly disparate people and agencies.
To show they're working together.
Exactly. You have to weave them into a single functioning association, in fact, enterprise. And that's why the complaint is so dense. It has to meticulously link a judge's alleged inaction to a police officer's affidavit, to a child support worker's policy, and claim it's all one continuous concerted scheme.
So, okay, let's start at the chronological route, because this entire sprawling federal civil rights case seems to have stemmed from something deeply personal and very localized.
A custody battle.
A custody battle. The specific inciting incident, according to this filing, it all begins in April 2024.
That's right. The complaint sets the baseline for us. The plaintiff, Jackson, he initially held 50-50 joint legal and physical custody of his minor sons, JEJ and ZWJ.
So things were, at least on paper, stable.
Stable, yes. The conflict wasn't about establishing custody from scratch, it was about modifying it. Early in 2024, the plaintiff filed a petition to, and this is key, increase his custodial time.
He wanted more time with his kids.
Yeah.
And the complaint frames the very next action by the other parent, defendant Kelly M. Law, as immediate retaliation for that.
Precisely. Jackson claims that as soon as she got notice of that custody modification petition, she launched a calculated retaliatory campaign.
And what did that campaign look like?
It allegedly began with lodging false accusations, specifically that the plaintiff permitted his son, JEJ, to possess or use a marijuana vape device.
Okay, so a very serious allegation against a parent.
Extremely serious. And this unverified allegation became the immediate trigger. It was used as the lever for procuring an emergency custody change.
Let's get into the alleged procedural failures around that emergency order, because this detail feels absolutely foundational to the entire due process claim later on.
It is. The plaintiff claims defendant Law procured an unlawful emergency custody order.
And what makes it unlawful in his view?
Well, the complaint states that while the plaintiff was literally en route to pick up his sons on his appointed day, he received a text message.
A text message.
A text message purporting to be the emergency custody order. The plaintiff explicitly argues this was not lawful service according to the Pennsylvania rules of civil procedure.
I mean, that just sounds wrong on its face. You get stripped of custody via text?
It's a massive procedural red flag. The complaint alleges this was deliberate. When we talk about due process, we're talking about the right to notice and the right to be heard. If the notice itself is unlawful, then the subsequent seizure of the children is tainted from the very beginning.
So this failure of proper service, it's not just a technicality, it's pivotal.
Absolutely. It becomes the basis of the claim that the initial custody seizure was conducted without due process. It means his property interest, his right to custody, was taken without the required legal protections. And this specific allegation, it resonates throughout the entire complaint, especially when we get to Judge Bononi's alleged failure to fix that exact defect.
And to bring this home for the listener, the complaint uses some incredibly specific and frankly raw emotional details to support the claim of parental alienation that was happening around the same time.
Yes, the exhibits include text messages from the son, JJ, which the plaintiff cites as evidence of coaching or manipulation.
What does it say?
That's where the emotional weight is heaviest. The texts show the son using extremely strong accusatory language. He references the alleged vape device, but then he also references the plaintiff's legal actions.
He knew about the lawsuits.
It seems so. The quote is, "I don't want to see you anymore. You done did too much sick shit like them millions of lawsuits just because you're mad." And then later, he calls the plaintiff a shitty dad.
Wow.
Jackson submits this not just as proof of his own emotional distress, but as concrete evidence of alienation and manipulation that he claims the court system just completely ignored.
So this dual-pronged attack, the false allegation and the alienation, was already in motion. And that's before the criminal justice system even got fully involved.
That's right.
So let's talk about that. The law enforcement involvement, specifically Trooper Antonio S. Maffa of the Pennsylvania State Police.
The criminal path was initiated, according to Jackson, based only on those unverified, retaliatory allegations from defendant law.
So no independent investigation first.
The complaint alleges no. Trooper Maffa filed criminal charges: corruption of minors and endangering the welfare of children. These are serious felony charges.
And this is a crucial element of the overall scheme he's alleging.
It is, and the most specific and I think most damaging counter-allegation against the trooper is that Jackson produced audio evidence.
Audio evidence of what?
Proving Maffa had lied in his affidavit of probable cause.
Wait, lied about what specifically?
Maffa allegedly stated in the official affidavit, a sworn legal document, that he had attempted to call the plaintiff's phone number to get his side of the story before filing charges.
And the audio proves.
Jackson's evidence allegedly proves this was false. That Maffa never made the attempt, this is not a minor detail, an allegedly false statement made under oath in a legal document which leads directly to criminal charges.
That's a huge deal.
That constitutes obstruction of justice and falsification of records, both of which become key predicate acts for the RICO claim later on.
Okay, here's the truly bizarre twist in the story. The thing that makes the claims of institutional bias so compelling. Let's talk about the clearance by the Children's Bureau, or CYS.
This is where you see the alleged systemic breakdown in its most visible form. Kelly Henry, she was the Children's Bureau caseworker. She investigated the matter thoroughly.
The vape pen allegation.
Vape pen, everything. And the complaint includes documentation that she cleared the plaintiff of all allegations.
Cleared him, so found no evidence.
Found no evidence of abuse, neglect, or drug exposure. The Bureau later sent a letter, which is included as Exhibit D, confirming the case status was officially unfounded.
Unfounded.
That CYS clearance letter essentially exonerated Jackson on the core factual issue that was underpinning the entire custody seizure and the criminal charges.
So you have the state agency that is specifically tasked with protecting children saying, no, there's nothing here.
Correct.
Yet the criminal process continued anyway.
Exactly. Despite the official CPS clearance, Trooper Maffa and the district attorney's office under Nicole Ziccarelli allegedly proceeded with the criminal charges. Jackson was then required to enter a diversion program.
Which included what?
Mandatory parenting classes, an evaluation by SPHS, Southwestern Pennsylvania Human Services, all the hoops.
Why? I mean, this is the question. Why would the DA continue a prosecution or even require a diversion program if the underlying factual allegations were deemed unfounded by their own county agency?
The complaint argues this proves the motivation was malicious prosecution and abuse of process. The objective wasn't child safety, because CYS had already confirmed safety.
So what was the objective then?
The complaint alleges it was to use the criminal process to coerce Jackson, to subject him to burdensome, costly requirements, and to leverage that criminal cloud hanging over his head to keep the modified custody order in place.
It becomes a weapon?
A weapon of coercion. The complaint notes that even after he passed all the mandatory evaluations, passed your analysis, the SBHS evaluators, like one named Madeline Hill, still submitted treatment recommendations. This suggests, in his view, that the process was predetermined to find fault and require his continued compliance regardless of the facts.
That detailed chronology, it really sets the stage for the federal constitutional claims. So now we shift into the legal bedrock of the lawsuit, the civil rights claims under 42 U.S.C., Section 1983.
Which, just to remind you, is the law that allows citizens to sue government actors for violations committed under color of state law.
This is where we define the mechanism of the alleged harm. Counts 4 and 2, they address procedural and substantive due process guaranteed by the 14th Amendment.
And to simplify for the listener, procedural due process is about how the government acts. Did you get proper notice? Did you get a fair hearing?
And substantive due process.
That's about what the government did. Was the action itself fundamentally fair and not just completely arbitrary?
Okay. And the heart of count 1, it seems to be the alleged failure to provide any meaningful opportunity to contest the seizure of his children. And the initial target here is Judge Mikel G. Benoni.
The specific allegation against Judge Benoni is her alleged failure to remedy that initial unlawful service of the emergency custody order.
The text message.
The text message service. The complaint argues she knew about this procedural flaw but allowed the seizure of custody to proceed and remain active without any hearing or review.
So, by knowingly ignoring a fundamental flaw.
The complaint argues she acted under color of state law to deny Jackson his basic procedural protections regarding his parental rights, which the courts have long recognized as a fundamental liberty interest.
Now, that distinction is key. For a judge to be successfully sued under Section 1983, they generally have to have acted outside their judicial capacity or in the complete absence of all jurisdiction. Is failing to correct a service error enough to overcome judicial immunity?
And that is the enormous legal hurdle that Jackson faces. It's a very high bar. He tries to tackle it by arguing her inaction wasn't just an error. He claims it was willful and malicious, part of a pattern of obstruction, not just a simple administrative oversight.
So the argument is that by allowing the continued deprivation of custody, based on what he calls a fraudulently procured, unlawfully served order, she stepped outside the bounds of a protected judicial function.
And into the realm of a constitutional violation. That's the argument.
Then, the docket shows Judge Benoni recused herself in May 2025, and the case was reassigned to a new judge, Matthew R. Schmitzy. Did the pattern of alleged denial end there?
Well, according to the complaint, not at all. The alleged pattern immediately continued.
In what way?
Judge Schmitzy is accused of refusing to consider Jackson's valid evidentiary submissions.
Like what kind of evidence?
Crucial evidence. The CYS clearance letter, for one, documentation regarding the children's mental health issues, their alleged drug use, and all the evidence of parental alienation he was trying to present. He is further accused of just dismissing Jackson's motions outright, often without giving them any meaningful review.
So it's painted as judicial obstruction, just continuing the denial of a neutral forum.
That's the narrative.
Let's focus on the equal protection claim, which is in count 2 and count 12. This often resonates deeply with listeners who are navigating the system alone. It's about being treated differently.
Yes, and this is a major structural critique of the local system in the complaint. Jackson, who is identified as a disabled combat veteran, alleges he was subjected to targeted, discriminatory, and disparate treatment.
Based on what?
Specifically because he was pro se representing himself, because of his veteran status, and crucially because he had previously filed other legal actions challenging the court system itself.
Oh, retaliation, essentially.
He's alleging a pattern of retaliation. The denial of evidentiary hearings, the automatic dismissal of his motions, the perceived judicial hostility, all of that is cited as evidence that he was treated fundamentally differently than, quote, similarly situated litigants who had not challenged the system or who were represented by counsel.
So the claim isn't just that the judge ruled against him. It's that the judge denied him the opportunity to even present his case, an opportunity that other litigants would routinely receive.
Precisely. Equal protection means the state can't apply laws differently to people who are fundamentally alike. Jackson is arguing that the court created a separate hostile track for him because he was an adversarial pro se litigant and a veteran receiving protected benefits.
Moving to count 7, this count directly attacked the integrity of the court system itself, alleging judicial misconduct and denial of a neutral forum.
This count is really the legal confluence of the due process and equal protection violations. The claim is that both judges Bononi and Schmitzy, and by extension DA Ziccarelli, willfully refused to review valid evidence. They obstructed the presentation of his claims and ensured the deck was stacked against him.
The core constitutional guarantee being violated here is the right to a fair and impartial tribunal.
Right. If the judge has prejudged your case or simply refuses to look at dispositive evidence like the CYS clearance, you are, by definition, stripped of any meaningful judicial recourse.
And to anchor this claim, the complaint revisits Judge Bononi's alleged willful disregard for that initial service failure.
Yes. The filing reiterates that Judge Bononi knew Jackson was fraudulently served via an unlawful text message, a clear procedural violation, but allegedly took no corrective action. This knowing, deliberate inaction is presented as evidence of a willful constitutional violation. And again, that's the key to trying to penetrate judicial immunity.
And it wasn't just the judges. The complaint also targets the actions of attorneys who were representing the county agencies. What about Attorney Emily Geiger, who represented domestic relations?
This detail, referencing the Exhibit E transcript from June 10, 2025, is pretty shocking if true.
What does it say?
Attorney Geiger allegedly admitted on the record that her office had received a stack of Jackson's legal filings, motions, demands, evidence. But she said they had an internal policy not to respond to them.
Well, she admitted that in open court? A policy of just ignoring filings.
That's what the complaint alleges she said on the record.
That's essentially an open admission of procedural denial.
That's exactly how the plaintiff frames it. He presents this as a confession of systematic due process denial. The Domestic Relations Office, by allegedly having a policy of intentionally disregarding legal notices from a specific litigant, was actively obstructing the judicial process.
So we have this documented pattern of alleged procedural missteps, judicial inaction, and admitted disregard for filings. It all contributes to this picture of systemic, coordinated exclusion.
The sheer volume of specific, documented procedural failures is what Jackson uses to argue that this was not a series of unfortunate mistakes, but a deliberate pattern of conduct designed to achieve an unlawful end.
Okay, Section 3. This dives into what the complaint frames as the core financial motivation behind the entire alleged enterprise. We're talking about the manipulation of child support enforcement.
This is where things get highly technical, but these claims are crucial for establishing the financial motive for the alleged racketeering.
So we're looking at counts IX and 14.
Right. Let's start with Title 4D. This is the federal program under the Social Security Act that lets state domestic relations offices enforce child support, often using powerful federal mechanisms.
Okay, and what's the key detail here?
The crucial rule is that to enforce support under Title 4D, the agency must first comply with federal rules. And that includes having a valid, signed application or contract for services from the custodial parent, Kelly M. Law.
So the plaintiff's argument is basically no contract, no case. If the county lacks that valid contract, they lack the legal jurisdiction to enforce the support obligations under the federal Title 4ED program.
That is the central legal argument he uses to establish fraud. Jackson claims he requested proof of this valid application multiple times through formal filings, motions, and even Pennsylvania right-to-know requests. And this foundational documentation was allegedly never produced. The complaint asserts that this failure to provide proof of jurisdiction invalidates all of the subsequent IVD enforcement actions against him.
The source material also indicates there was significant confusion or maybe intentional obfuscation around the actual IVD status of the case.
Yes, Exhibit F is key here. It documents contradictory statements from Jacqueline Henry, an officer at the Westmoreland County Domestic Relations Section, or WCDRS.
What did she say?
She initially told Jackson the case was not Title 4BD, but later she stated it was an IVD case. This shifting position is alleged to be fraudulent concealment of jurisdictional defects.
So he's arguing they were deliberately misrepresenting the legal basis of the enforcement to keep collecting money.
Exactly, to maintain control. Because Title 4 VD cases bring in federal money and federal administrative powers, including the ability to levy assets. By allegedly misrepresenting the status and lacking the proper contract, the county could maintain the appearance of legal authority while benefiting from the financial mechanism.
Which would constitute a pattern of fraud.
A pattern of fraud necessary for the RICO claim.
Now let's get to the second half of this financial claim, which is especially powerful because it involves a protected federal status, the unlawful garnishment of his combat-related special compensation, or CRSC.
This is perhaps the most damaging financial claim in the entire document.
Explain what CRSC is for us.
CRSC is compensation paid to combat injured veterans, and federal law, specifically 38 U.S.C. Section 5301, explicitly exempts CRSC from garnishment, levy, or seizure for child support. It's considered non-disposable and non-taxable. The law is crystal clear.
So this isn't just any income. This is federally protected money specifically for combat injuries.
Absolutely. And the plaintiff asserts he never provided a waiver allowing this garnishment.
So Jackson is alleging that the WCDRS, along with defendants Kelly M. Law, Amanda Farrer, and Emily Geiger, actively continued enforcement and garnishment against these protected funds?
While knowing his veteran disability status and knowing they lacked the legal jurisdiction over those specific federal benefits.
This sounds less like an administrative error and more like, well, willful financial exploitation of a disabled veteran.
That is precisely the allegation. Furthermore, the complaint alleges that when Judge Schmissy was presented with clear evidence of the CRSC garnishment, the legal proof that this money was protected, he allegedly refused to consider the evidence.
So he allowed the illegal practice to continue under the color of judicial authority.
Which integrates that action, or inaction, into the larger pattern of due process denial and fraud upon the court. The argument is that the county system had a massive financial incentive to keep the support case active, regardless of jurisdictional flaws like the missing IVD contract or the protected nature of the funds.
So this lack of a contract, coupled with the illegal garnishment, it establishes the financial motive and the specific legal injury for the racketeering claims he's making.
It shifts the case from a simple child support dispute to an alleged systematic attempt at illegal wealth extraction.
Okay, here's where the complaint shifts into high gear. It transforms the civil rights case into a serious allegation of organized corruption using federal criminal statutes. The Racketeer Influenced and Corrupt Organizations Act, RICO.
And we should remind the listener, RICO is the federal law that was designed to prosecute the mob, major organized crime. Jackson is applying that same standard here.
Which is why these counts V and XX are the heaviest lift in the entire complaint.
Absolutely. Jackson alleges the defendants collectively formed an association in fact enterprise, which he explicitly names the Westmoreland County Racketeering Enterprise.
And to prove this, he has to show what?
He has to show continuity, a structure, and a common purpose among all these different defendants.
What was the alleged common purpose of this enterprise, according to the complaint?
It outlines 4 alleged goals. First, financially exploiting him. Second, unlawfully extorting assets through fraudulent child support enforcement, especially the CRSC. Third, obstructing justice by suppressing evidence in his motions. And fourth, depriving him of his legal and constitutional rights, specifically custody.
And to sustain a RICO claim, you need to prove a pattern of racketeering activity. That means showing 2 or more specific, related criminal acts called predicate acts.
Right. And the list of alleged predicate acts is extensive because the complaint argues every administrative and judicial action was part of the scheme. This is what links the judges, the police, and the domestic relations employees together.
So walk us through them. What are the big ones?
First, you have mail fraud and wire fraud. This covers mailing fraudulent child support documents, allegedly altered court orders, and digital misrepresentations through the e-filing system, all used to perpetuate the scheme.
Okay. What's next?
Falsification of records. This is crucial. It points directly to the false affidavit of probable cause filed by Trooper Maffa and the misrepresenting of the Title 4B status by WCDRS personnel.
Then you have obstruction of justice.
Yes, and this directly ties to the judicial defendants. It covers suppressing the exonerating CYS findings, the alleged destruction or withholding of the Title 4BD applications, and the persistent refusal by the judges to acknowledge the documented legal defects.
The complaint also alleges extortion.
Under the Hobbs Act, yes. It claims the defendants coerced Jackson to pay illegal child support, specifically the protected CRSC funds, under the direct threat of being thrown in jail for contempt.
Which is a clear claim of extortion under color of law.
And finally, a really serious one: kidnapping or custodial interference. This is characterized as the wrongful and prolonged withholding of his children without a lawful constitutional basis, achieved through those fraudulently procured orders.
That is a staggering list. It effectively connects every individual defendant's alleged failure into a single, unified criminal objective.
That's the strategic power of a civil RCO claim like this. It forces the court to look at the actions not as isolated mistakes, but as a deliberate, patterned course of conduct. It transforms the civil dispute into an allegation of organized institutional criminality.
And let's talk about the conspiracy element, counts the 3rd and 8. How is this conspiracy specifically coordinated?
The conspiracy is alleged to be coordinated through that pattern of unlawful acts: falsifying documents, systematically denying him legal notices, and manipulating the enforcement mechanisms. The explicit objective, he claims, was to extort financial payments through the unlawful CRSC garnishment.
This brings us to a highly unusual and, frankly, painful part of the complaint, the role of Jackson's own former attorneys.
Yes, he includes very serious allegations against attorneys Jacqueline Shaw and Alyssa Bartling of the Shaw Law Group.
These are allegations of what? Malpractice? Complicity?
Both. He argues they effectively aided the wire conspiracy. The complaint alleges his own attorneys failed to represent him properly, actively discouraged him from filing crucial contempt motions, and negotiated unlawful agreements while he was under duress.
The implication is that they prioritized just going along with the system over their duty to their client.
And that they did so while allegedly knowing that the underlying facts, like the CYS clearance, should have terminated the entire legal action. It adds this layer of betrayal to the narrative.
That the plaintiff was allegedly being squeezed not only by the government, but by the very people he paid to protect him.
It solidifies the idea of a pervasive systemic issue. And this RICO framework is essential because successful claims allow the plaintiff to seek maximum financial relief, which is triple damages.
Beyond the massive constitutional and financial claims, the complaint delves deep into the personal and emotional toll this alleged misconduct took on Jackson. Let's start with malicious prosecution, count the 6.
Malicious prosecution is a specific tort. It requires proving 3 things: that criminal proceedings were initiated without probable cause, maintained without factual support, and ultimately terminated in the plaintiff's favor.
And the CYS clearance is the core piece of evidence he's using to prove that lack of probable cause, right?
Exactly. He argues the charges were initiated based on a knowingly false affidavit from Trooper Maffa, and they were maintained even after CYS found the allegations unfounded. He asserts that DA Ziccarelli proceeded with prosecution even after being made aware of the CYS findings, which he claims demonstrates a malicious intent.
And by forcing him into that diversion program, they sustained the prosecution unjustly.
Fulfilling the second element of the tort.
Okay, next, count ex litem addresses defamation, both libel, which is written, and slander, which is spoken. Who are the key defendants here?
The primary focus is on attorney Amanda Farrer, who was representing the custodial parent. The complaint alleges that attorney Farrer stated in open court, on the record, that Jackson was mentally ill and dangerous.
Wow.
And that his children were deathly afraid of him. The critical point is the claim that these statements were made without any supporting medical evidence and with reckless disregard for the truth.
Stating that a parent is mentally ill and dangerous in a custody proceeding. I mean, that's the nuclear option. That's game over. The impact must have been immediate and severe.
It is. The plaintiff alleges these remarks were made with malicious intent specifically to sway the court, to create a biased record, and to justify the ongoing denial of custody. Furthermore, defendant law is alleged to have repeatedly made false accusations about the vape pen incident, and Trooper Malfa's allegedly false affidavit is cited as written defamation libel that misled judicial officers.
And finally, let's cover the sheer emotional impact detailed in counts X and Hexting, intentional and negligent infliction of emotional distress.
These counts capture the overall consequence of the alleged conspiracy. The complaint describes the defendant's cumulative conduct as intentional, malicious, and so outrageous that it exceeds the bounds of decency.
What kind of harm does he list?
The list is extensive. Severe depression, anxiety, insomnia, loss of reputation, humiliation, and most damagingly, profound alienation from his children and the long-term estrangement of that father-son relationship.
The argument here is that the concerted action of all these defendants amounts to psychological torture, stripping him of his most fundamental rights and relationships.
Precisely. This section underscores that he's seeking redress not just for financial harm or technical legal violations, but for a profound malicious assault on his personal life and reputation that was allegedly orchestrated through the very system designed to protect him.
We have dissected the sprawling allegations of the complaint filed in August 2025. Now let's move forward to the present, January 2026, and look at the federal docket to see how the U.S. District Court has responded.
Looking at the docket, the volume of activity in late 2025 and early 2026 is enormous, which is standard for a case with this many high-level defendants.
And they immediately went on the offensive, I assume.
Absolutely. The vast majority of filings in December 2025 were motions to dismiss the complaint entirely.
On what grounds?
Typically two main arguments. First, failure to state a claim upon which relief can be granted, basically arguing that even if Jackson's facts are true, they don't legally amount to a violation. And second, lack of subject matter jurisdiction, trying to say these claims belong in state court, not federal.
So they're trying to dismantle the entire case at the earliest possible stage, before discovery can even begin.
That's the goal.
So we have a federal judge facing this huge pile of motions to make the case just vanish. But amidst all that, the court had to address immediate time-sensitive issues. We see the filing of a temporary restraining order, a TRO, on January 5th, 2026.
And a TRO is a huge pretrial move. It's sought when a plaintiff argues that immediate and irreparable harm is currently happening and will continue before the court can even rule on the case itself.
He was likely seeking protection from the continued garnishment.
The continued garnishment of his CRSC funds, yes, and any further negative action in state court.
And just 4 days later, the docket shows an order on motion for preliminary injunction. Now, why is the judge ruling on immediate relief before addressing all those motions to dismiss the entire case? What does that tell us?
It tells us two crucial things. First, the district court judge recognized the urgency. A TRO and a preliminary injunction require the plaintiff to show a likelihood of success on the merits and demonstrate they will suffer irreparable harm if the court doesn't step in.
So the fact that the court even issued an order on the injunction,
it suggests they found at least some merit in the claims of immediate continuing harm. It compelled them to rule on temporary relief before tackling the much slower process of deciding on the motions to dismiss. This suggests the court is taking the claims of illegal garnishment and ongoing constitutional violation very seriously.
that is a significant procedural development. Finally, let's look at the prayer for relief. What exactly is Jackson demanding from the court?
The relief sought is massive. It's commensurate with the severity of the allegations. He wants declaratory and injunctive remedies and absolutely substantial financial compensation.
Let's start with the money. How large are the damages?
He seeks compensatory damages of $5 million for emotional distress, reputational harm, loss of custody, and so on.
And punitive damages?
Punitive damages of $25 million. That's intended to punish the defendants and deter future misconduct. And because of the RICO violations, he's seeking treble damages.
Which means the court should triple the proven actual damages.
Pursuant to federal law, yes.
So if the court found, say, $10 million in damages, treble damages would push that to $30 million. These are astronomical numbers.
They're designed to reflect the scale of the alleged institutional failure. And of course, he demands full restitution of all unlawfully garnished CRSC payments.
Beyond the money, the requested injunctive relief is arguably more critical because it targets the ongoing systemic issues.
That's right. It seeks systemic change. He demands several permanent injunctions.
Like what?
A declaratory judgment confirming his rights were violated, a permanent injunction prohibiting any future garnishment of his protected veteran income, a critical order for the termination of the Title 4D enforcement activity in his case based on that lack of a valid contract.
And vacating the old court proceedings.
Yes, vacating all family court or criminal proceedings initiated by fraud, and an order compelling the immediate restoration of all his parental rights and full custody of his children.
And finally, he requests criminal and ethical accountability.
Yes. He seeks a mandatory referral of the entire matter to the U.S. Department of Justice for investigation into potential judicial and prosecutorial misconduct, perjury, and fraud, and referral to state disciplinary boards.
This full prayer for relief is a demand not just for compensation, but for the complete dismantling of the alleged enterprise that he claims caused his injury.
It's a highly aggressive and comprehensive remedy package. It reflects the plaintiff's position that the injury was not an accident, but the result of institutional corruption.
So after all that, what does this all mean for you, the listener? This deep dive into Jackson v. Ziccarelli et al., it really highlights the extraordinary lengths a pro se litigant went to. Not just to sue, but to meticulously document and fight an alleged systemic abuse that crossed nearly every local legal jurisdiction.
I think the crucial connection reinforced throughout this 50-page complaint is the link between procedural compliance, or the malicious lack of it, and the protection of fundamental constitutional rights.
Little things become big things.
Exactly. Whether it's the proper service of an emergency custody order or having a valid Title IV VD contract for child support, Jackson successfully links the failure on these seemingly minor procedural points to a massive, concerted effort to deprive him of fair treatment and liberty.
The complexity of these claims, it really underscores a painful vulnerability. This complaint doesn't just allege that state systems were failing on their own, but that the judiciary, law enforcement, social services, child support, they were allegedly operating in concert.
And this claimed systemic collusion highlights the profound danger inherent in navigating these systems at the same time, especially when you're faced with institutional hostility.
The complaint explicitly describes the use of the legal system in this case as a weapon, not a forum for adjudicating real disputes.
And that phrase, it just encapsulates the entire narrative. Jackson is arguing that the processes designed to ensure justice were deliberately hijacked for financial and retaliatory objectives, turning due process into coercion.
So here's a provocative thought for you, the learner, to consider as you process all this. The complexity of this civil INO claim, the detailed chronology, the specific citations of federal criminal statutes, the cataloging of every single motion denial, preserving exhibits like the CYS clearance letter, it all demonstrates an incredible professional level of legal research and record keeping.
It really does.
So the question is, if this incredibly sophisticated detailed litigation is required just to gain the right to argue complex federal claims like RICO against the very entities that control the local justice system, does that level of effort and skill become a prerequisite for justice itself when systemic misconduct is alleged?
It raises a serious question, doesn't it? Is true accountability truly accessible when the documented facts and the legal statutes appear to be consciously suppressed by the parties entrusted to uphold them, forcing a citizen to resort to the highest federal civil law remedies merely to get a hearing?
It challenges the very idea that a local judicial system can police itself when it's facing these deep-seated allegations of financial self-interest.
A truly challenging and sobering deep dive into the anatomy of a civil racketeering complaint against the local judiciary.
Thank you for taking this journey with us and for exploring that fine line between administrative error and alleged organized crime in the courtroom.